Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office with attorney Codi Dada, founder of the Codi M Dada Law Offices in Novato. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Shameika Rhymes, and Codi is here to help us cut through the legal jargon to help you protect your assets, avoid the headaches of probate, and leave a lasting legacy for your family. Codi, thanks for being here.
Thank you, Shameika. My pleasure to be here.
It's good to see you again.
Likewise, thank you.
Well, what exactly is trust administration?
Well, trust administration is the process of transferring assets to the named beneficiaries. It's a multi-step process, and it requires the trustee who is named in the trust to take legal title over the assets and perform a series of steps like identifying all the assets, providing notices to the beneficiaries, paying the taxes, settling the final obligations, and ultimately distributing the assets to who's named as a beneficiary in the trust.
Okay. Well, when does the job as successor trustee officially start?
The job starts when the trustee accepts the duties as a trustee. At that point, they have what's called a fiduciary duty. They have a legal obligation to do things a certain way. They can either formally accept by signing an acceptance or simply begin taking on the tasks of a trustee. Usually what it takes is they go to the banks and other financial institutions with either a doctor's note that indicates that the person, the trustor, the person setting up the trust has now become incapacitated or they have passed. At that point, the financial institutions will acknowledge the trustee as the successor and allow them to step in and have access to the bank accounts and other financial assets, as well as real estate and all other assets that are properly titled in the name of the trust.
Well, if someone is named as the successor trustee, are they legally forced to do the job, or can they turn it down if it's like overwhelming and it just feels like it's too much?
Right. No one's forced to be a trustee. So if it's overwhelming for someone, they can simply decline and allow the next person who's been appointed to step in and take the role. They do have a duty to inform the successor if they're not aware that they are in line to take that responsibility. The complications come in if there is no successor trustee, then we have to petition the court and have the court appoint a new trustee if the trust document doesn't provide instructions on how a new trustee would be selected.
Okay, so I think we need to talk about what exactly does the trustee need to do after a death?
That's a great question. So it's a multi-stage process. Unlike probate, this is a private process. It doesn't involve government involvement. And first you have to give notice to all the beneficiaries. So that you have to send out what's called a notice by trustee, along with a copy of the trust is preferred. And then you have to identify the assets, called marshaling the assets, and provide an accounting and an inventory list to the beneficiaries. You also, as a trustee, are required to file the final taxes for the personal taxes and for the estate taxes, pay the final obligations, credit cards, funeral expenses, what other financial expenses are remaining, protect the assets, secure the home, and keep the money safe but productive and diversified. It's many legal duties that a trustee has to do, and they have to be super honest and keep detailed accounting, and they have to avoid conflicts of interest, and everything they do has to be calculated for the best interest of the beneficiaries. Once the assets are identified, the taxes are prepared and filed, then They will send out notices to the beneficiaries reporting what they've done and allowing the beneficiaries to review everything and informing them how much money is available for distribution. Once the beneficiaries agree and it's clear that there is no disputes or outstanding items, that's when the trustee actually distributes the money to the beneficiaries.
Well, is a trustee personally liable for the trust maker's debts?
A trustee is not personally liable for their debts unless they mismanage the assets. So they have what's called a fiduciary duty, which means they have a legal obligation to do things a certain way. One of those legal obligations is to pay the final debts, settle any final obligations of the estate. And if they don't, and they distribute the money to the beneficiaries without holding a proper reserve, and later discover that there are assets or obligations that should have been settled, then they could be responsible personally for not fulfilling their fiduciary obligations. But other than that, typically a trustee is not personally liable for the debts and the financial obligations of the trust estate.
Well, who pays for the attorney and the cost of administration?
The attorneys and the cost of administration are paid from the actual estate assets. And the law is written in a way that allows others to finance the trust administration, knowing that they'll get reimbursed later from the trust estate. No one is personally responsible to pay for those expenses out of their own pocket, but oftentimes before assets can be located, it does require someone to advance the costs, knowing that they will get paid during the course of administration.
So when you say advance the cost, that means out of their own pocket?
Yeah, sometimes the
Okay.
assets aren't easily identifiable, and there's a little time period where the banks need to acknowledge the trustee as the successor. They need to fill out some paperwork and send it to the legal department. So bank accounts aren't readily available. But in the meantime, things have to get paid and there's bills to settle. So oftentimes one of the family members will advance and pay out of their own pocket those types of fees to initiate the trust administration. And then later on, once the accounts are identified and accessed, the law provides that those people will be repaid and reimbursed from the trust estate, from the assets of the trust.
Okay, that makes sense. Well, when is the right time to give the money to the beneficiaries? Can it be done all at one time?
It's very important that the process is followed. The problem is if you distribute the money too soon and then you later find out that there's certain bills that weren't paid or taxes that need to be paid, it's very difficult to get money back from people once they've received it. So there's a process where the assets are identified, the accounting is prepared, and then during the process, a reasonable reserve is calculated based on next year's taxes or any outstanding financial obligations. And then that reserve is withheld for a period of time until the trustee is absolutely certain that there's no other financial obligations of the estate. Once that process has been completed and the trustee has a reasonable reserve set aside, it's often a good idea to distribute the money to the beneficiaries. But before then, it's very risky to distribute the money. And oftentimes, it takes several months for the beneficiaries to receive their inheritance because there's certain things that have to be completed before the money can leave the estate, such as filing taxes, paying final obligations, credit cards, selling real estate, paying for property taxes, and other miscellaneous debts.
Well, if the goal of a trust is to avoid lawyers and courts, why is it still important to have a lawyer guide the trustee through the administration?
Well, a trustee has legal duties and they're required to do things a certain way. The good news is that trusts are much more efficient to administer and less legal help is needed. But normally, trustees are individuals who aren't aware of their responsibilities and the procedures required. So it's recommended that they at least consult an attorney to get a little bit of consulting and coaching and understand the different processes required so they can fulfill their duties without getting into legal problems and conflicts with the other beneficiaries. Usually it's minimal required unless there's a complicated estate. But the bottom line is trustees have to be super honest and do things that make sense and avoid conflicts of interest. Oftentimes, people aren't clear on what that means, and an attorney, an estate attorney, can simply educate them on what they need to do and help them with the legal documents required.
Can you explain, like, or give an example of what a conflict of interest might look like?
Well, a conflict of interest would be using the estate money for the trustee's personal benefit, right?
Ah,
Um,
yeah.
or distributing money impartially, favoring one beneficiary over the other. Let's see. Another example would be investing or loaning yourself money from the estate, or using that money that benefits you unequally from the other beneficiaries.
Okay, thank you for those examples. How do we know when the trust administration is officially finished and the trustee's job is done? Or is it ever done?
Right. Yeah, it can linger oftentimes, but the work is front loaded. So first they have to identify the assets and create the accounting and file the final taxes and pay any other financial obligations. And then once everything's identified and we know how much money to hold back as a safety reserve, the money can be distributed. The trust administration is officially done when there's no more assets in the possession of the trust and that the trustee has no more legal obligations. So that could take years. And what we like to do is have all the beneficiaries sign what we call an acknowledgement and release that officially acknowledges that the trustee has fulfilled their duties and that all the beneficiaries agree that they are now done with their duties and they're off the hook. That makes sense?
Yeah, it does. This has made so much sense to me. And thank you for explaining this and going through all of the steps on a trustee's job.
Thank you, Shameika. It's been a pleasure to speak with you.
Well, thank you for joining us for the Trust and Estate Clarity with Dada Law Office with attorney Codi Dada. Please take a moment to subscribe, like, and share this episode with someone who needs to hear it. And for more resources or to start your own plan today, visit dadalaw.com. Thanks for tuning in, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.